welcome. Thank you for taking the time to come here. And we will begin by introducing ourselves. So I am Suchitra Balachandran. I am on the steering committee of Our Revolution Prince George's. Our Revolution Prince George's is part of our statewide chapter, Our Revolution Maryland, and I sit on the board of that organization. And that is under the umbrella organization of Our Revolution National. So if you're wondering what we do a lot of, our platform is very wide. It's basically deals with the domination of politics by corporate and elite interests and the fight for economic equality. On the economic equality agenda, which includes the fight for good unionized jobs, fair livable wages, permanent affordable housing, fair taxes. And I love this, resisting the heavy-handed support of the military-industrial complex and the international war machine. Environmental justice through the insistence of legislation that supports a livable planet, racial justice, criminal justice reform, universal single-payer healthcare, tuition-free public colleges, and getting big money out of politics. Of course, we don't engage on all of this in Prince George's because we don't have the capacity to do that, but that's our platform. So if anybody wants to engage on any of these issues, feel free to come and use our platform to work with. I just wanted to pass the mic on to Kelly Canvan. Kelly, do you want to introduce yourself?
Hi, I'm Kelly Canavan. I'm the president of the Amp Creeks Council, which is the Akahikamatawoman Piscataway Creeks Communities Council. We are based in Southern Prince George's, but we do work all over the state of Maryland and even throughout the Mid-Atlantic. We generally are focused on making the human and natural environments more pleasant places to exist in. And we do that largely through land use and zoning work, which often results in us filing lawsuits.
So my name is Jana Parker. I am a community activist. I work with several different organizations as an individual, but to push forward a progressive and wonderful platform in Prince George's County that makes gorgeous Prince George's gorgeous for everyone. And so one of the things is making sure that ethics are followed.
I'm Greg Smith. Hi, everybody. I'm on the board of Community Research and Sustainable Hyattsville. They're two grassroots Prince George's County-based nonprofits. We're all volunteer, and we have been fighting a particular development in Hyattsville since early 2018, and we are now we and our neighbors are parties to 3 lawsuits in state court, challenging decisions made by the planning board and the district council. So thanks for being here. We've been working on this bill for a month and a half or so, and it's really good to have an opportunity to share with you our perspective and what we know. Thanks.
And finally, a longtime activist from Cheverly, Dan Smith.
Thanks. Yeah, so I've been a founding member of Progressive Cheverly, and also helped start Friends of Lower Beaver Dam Creek, a watershed clean water advocacy group that focuses in the area within Lower Beaver Dam Creek within the Beltway, and helped develop the Cheverly Green Infrastructure Plan. So I've been involved with a lot of environmental and social justice issues for the past 35 years in the county. And right now, one of the issues that is concerning me, part of a group that's bringing a challenge to a development on the floodplain right south of Route 50 near the Cheverly Metro. And a concern is that when we're developing in the floodplain wetlands, there's some extra requirements to demonstrate that this is a development that really is necessary, that can't be done elsewhere, like outside of the floodplain. And that hasn't been done. It's been treated just as any other knockoff development. And that's particularly disconcerting right now when we have climate change, a global climate crisis. And I just feel that the process and the systems we have in the state and the county are way behind, and that so that's a concern of mine with this whole process.
Thank you, everyone. So just sort of some bookkeepings. If you have questions, please put them in the Q&A. That would be easiest for us to keep track of rather than putting them in the chat. Feel free to chat among yourselves if you like in the chat, but specific questions you want us to answer, please put it in the Q&A. So just walking briefly through the agenda, we'll start with kind of a conversation between the five of us on where this issue started from and how we find ourselves here. And then we have a PowerPoint that we will cycle through. And depending on who has sort of information to share, I think we might jump in at various points and say that. And then we will have lots of time for discussion after we finish that process. So I guess just to kind of start things off, the zoning rewrite. Who wants to take that on and say what that is about and what happened?
Kelly, you want to take that one?
Sure. So the zoning rewrite is a project undertaken by the Prince George's County Council. It's been about 6 years in the works at this point. Is that right? 6 years?
Yeah, I think 6 years.
6 years in the works. And the idea is to sort of tidy up, do some housekeeping with the current zoning ordinance. So the zoning ordinance as it stands now is a little messy. There are sometimes overlapping zones or confusing or conflicting things. And so that just needed like some sorting out. And at the same time, the council decided to try to streamline the application process for developers. That's been another goal of the rewrite. And to change how the community engages with the development application process. So there are a lot of things going on there. We feel variously satisfied or dissatisfied with those things, but that's what's been happening. And so with the zoning rewrite, which is just an administrative thing, comes a map amendment. So that is when the new zones are applied to the map of Prince George's County.
So I'm in a single family home and my zone is R55, so it would translate to some other.
Maybe.
Or
so there's
R65.
Yeah, so everybody won't have a change of zoning, but many people will. And for some people, it might have a different name, but it means the same thing, or there might be a slight difference in a small difference in density or allowed uses, things like that. But the idea is that it's supposed to just, again, like tighten things up and clean things up. There will be some changes, but they should be in line with the plans that guide the governance of Prince George's, so things like the master plans, the green infrastructure plan, all the functional master plans, things like that. So it really, again, is just an administrative process that it's not really a process for making applications to change your zoning. For example, if you want to build a shopping center where your house is now, it's not really the place to do that. Instead, you would do that through a separate process because that is one particular thing rather than something that applies to the whole county in a reasonable way.
And this zoning rewrite was legislated at the end of 2018.
That's right. It was legislated at the end of 2018, and now it's sort of hanging in flux because of this lack of quorum issue that we're going to get into.
Good. So somebody want to talk about the map amendment? Which is the next step?
We want to go to the PowerPoint now?
Do you want to
go to the PowerPoint?
Do we want to walk through that? I thought we just have sort of a discussion of this and maybe of the bill and then walk through the whole thing through the PowerPoint.
Well, it's all on the PowerPoint.
Yeah. And we can't hear you, Dan. Are you muted?
Well, I can just mention, you said you wanted to just a quick overview of the mapping.
Mm-hmm.
Okay, so the mapping, it's sometimes called a CZMA, a countywide zoning map amendment, and it sounds sort of jargony and overwhelming, but it really is just what the words say. It is countywide, and it is just an amendment to the zoning map. So right now, all of the land in Prince George's County is zoned as something. You may not know what it is, but all of your land, all the land you're sitting on is zoned as something. And through this map amendment, the new zones that are sorted out in the zoning rewrite will be applied to the map. So it's just a way of implementing the new zoning ordinance. So for example, if your house is going to change from RA to RE, that would be put on the map. If your house is going to stay the same, that is going to be put on the map, and so forth. Does that make sense?
Yeah. So really, I mean, if this was rewriting kind of the code and then doing a map overall, you think like, what is the problem and why is the county and the planning board and with input from the citizens not in fact able to go through this process, right? And that's where we're coming into the PowerPoint presentation to say, what exactly is the hitch and why are we leading up to legislation to weaken the ethics law? I mean, it seems like it's a good thing to do. You figure out what's wrong with all the piecemeal zone numbers you have, you change them, you have uniformity, everybody understands it. And then you stick it on the map of Prince George's and you say, okay, this is where this particular use is allowed, and this is where some other use is allowed, this is where we want the parkland and so on. So now we're going to get into basically, I think, understanding what the hitches are and why we are in this complete mess that we're in where the council is unable to make a quorum. So what we're going to do is share a PowerPoint presentation. There was one question, I think, saying what is upzoning? Somebody want to answer that before we move into it?
I think somebody did.
Okay, all right. Thanks. Okay, so let's get started with the PowerPoint.
This is a quote that's been out there for a while, and a lot of public interest groups that focus on transparency often quote Justice Brandeis as saying sunlight is the best disinfectant, and they're referring to public processes, corporate and government relations that may not be entirely on the up and up on what we expect of our governance. And next slide. So this is, we already covered a bit of this. It's an overview. Back in October 23rd of 2018, the council approved the zoning rewrite. This was a massive bill and lots of amendments were filed close to the 23rd. Kelly and I were among a group of civic and environmental activists who asked the council to hold off because it was such a massive bill and amendments were coming in late. And we thought that there were some substantive problems. So we asked the council to hold off so we could address these and get a fair look at the bill. They decided to go ahead and vote for it on their last legislative day before the general election. The rewrite does have some good points. It's got some points that we think are damaging. And one of the points that we're concerned about is it fails to eliminate a tool called a zoning text amendment. And that's legislation that doesn't go through the usual review process before the planning board and or the district council. It's a legislation that goes solely before the county council, and developers ask the county council to change the allowed densities or uses on a piece of land under certain conditions. I'm not aware of any, I don't have comprehensive knowledge, but my understanding is that the county council typically passes these. And from the text amendments that I've seen, there's generally very little or no assessment and disclosure of potential impacts, how many pieces of land would be affected, what the environmental and community impacts might be, just a piece of legislation, and there may be a policy note with it. But we actually fought a zoning text amendment that we argued would open up potentially thousands of parcels or hundreds of parcels across the county, to open space parcels and allow townhouses, and we were told we didn't know what we were talking about. And ultimately the planning staff did an analysis that kind of matched ours, and they said, oh, yeah, these guys have a point. This could do what they are saying. And yet council members told us we didn't know what we were talking about, and we're trusting their colleague who had put forth the bill. So once the council passed the zoning rewrite, they then had, the next step is for the council to direct the planning department to draft a countywide zoning map amendment that, as Kelly said, basically applies the new zoning categories to every property in the county. And our understanding is it's supposed to be sort of a one-to-one exchange. It's not supposed to be an exercise that increases the intensity of zoning or uses or densities on properties. The planning department did develop a draft CZMA. The council next has to convene a joint hearing with the planning board to hear public comment on the draft. They scheduled it in March of last year, but postponed it because of COVID. Then they were compelled then they scheduled it for November, but they were compelled to postpone again because of these ethics violations that have arisen, where a number of council members have received campaign contributions that are prohibited under the state ethics law, public ethics law. And that's where we are now. So in our opinion, so where we are now is the council went to the county delegation of the House of Delegates in Annapolis and asked them to put in a bill, and it was a county-only bill called Prince George's 416 that would exempt the countywide zoning map amendment from the requirements and the prohibitions in the public ethics law. And we put 3 points here. It would undermine these provisions. And these are really common sense protections. We'll get into a few of the details later, but they're there to ensure transparency in land use and zoning and to prevent undue developer influence through campaign contributions. There are general provisions that apply to all jurisdictions across the state. And then there are sections of the public ethics law that apply to specific counties. And it varies from county to county. They're not all the same. There's some similarities. Next.
I do want to point out before you continue, I know there's, first of all, I know there's a county council person in the chat. Hello, county council person, Theros. I just want to be clear that I'm here, that I know that you're present when I'm going to say this. The timing in which this bill was submitted to the Prince George's County delegation seemed to be very inappropriate. So the Prince George's County delegation, by the Constitution of Prince George's, has to submit all bills to the public for comment prior to the legislative session. Anything that comes after would be called a late file bill. The county council, knowing this, knowing the issues, knowing that they couldn't vote, knowing that they couldn't have a quorum, did not request this bill in a timely manner and did wait and have the bill filed as a late file bill, almost in what appeared to be an attempt not to inform the public of these issues. Even the presentation of this bill, which would be altering the ethics provisions, was just really centered around, hey, we need to rezone, we need to rezone, we need to rezone, and did not clearly articulate the issues around changing the ethics bill as to why we have this ethics bill to begin with. It was very, very, very disappointing. There was a hearing within Prince George's County because it was a late file bill. And when it was a late file bill, there were people who presented on that on both sides, opposing and in support. But I just want to be clear that this was an issue that the county council knew about for several years because they had been working on their zoning rewrites for several years and had not spoke to the residents about the issues, but just simply put forth a bill through the delegation and then did it in a late file manner that seemed to be very sneaky.
Right, and so I wanted to add to what Jana said by having a couple of comments on how that hearing went. The hearing was in February, right? So you only hear about it if it is in December, then most people who are paying attention to delegation bills show up at the hearing. But in February, you only hear this bill is being heard if you're on the list and you actually get an email from the Prince George's House delegation saying that this hearing is happening. And some of us did attend and we did give testimony. But this bill has, the bill then went, if I could take a minute to say that, it went to the County Affairs Committee, where a hold was put on the bill and a sunset amendment was added to it. And then it went to the full delegation for a vote. And there was the entire conversation in the full delegation took all of 3 minutes because there was no discussion. The bill was called, the bill was voted on, and that was the end of it. So I think, overall, the oversight on this bill has been very limited in the Prince George's delegation. So handing it back to you.
And I also want to reiterate how much they knew prior to this, because there was a joint legislative priority session before this session started in the MGA, and before the bills and everything like that. And Todd Turner actually presented on behalf of the county council and spoke directly about needing the Prince George's County delegation to pass a bill for these zoning rewrites. So that statement happened before there was even a presentation about the bills that were filed on time to the Prince George's County people. So this is something they knew about. This is something they knew they were going to request. They didn't do it in a timely manner, and it gives the sense that this was all done to cut out voters who vote for them from the information about a very important bill.
Yeah, and I'm not going to. I try not to pretend to be able to mind read, but I will say that the council had a reason to know that this ethics conflict could come up, and it's very clear in the law that zoning map amendments are covered by the ethics law. The council knew by at least early November that there was a serious issue, but the bill was filed by the delegation on around January 20th, and then there was this hearing shortly after. And as Suchitra said, the delegation spent all of about 3 minutes discussing the bill before approving it and taking it then to the full House of Delegates. So there were opportunities for more disclosure, for more transparency, for more input, and they didn't happen. So why don't we move along?
Yeah.
And sorry about the reflection on my glasses, folks, but I can't read chat without them on. You want to go to the next slide, or?
Oh, okay, sure. Oops.
Right. So, was that the PG? Was that the Prince George's one?
Yeah. Do you want to go back and speak to
Yeah,
that?
go back
sorry.
to that real quick. Just real quick.
Okay.
I'm gonna be like 30 seconds.
Sure. There we go.
So Prince George's County is not unique. This is very true. The ethics law applies specific requirements and prohibitions to other counties, including Montgomery County, Howard County, Frederick, and Anne Arundel. It also applies to city, town, and local boards of education and other bodies. So this is not like, sometimes we hear in the public arena from our delegation who put forth these bills to begin with, that the bills that they put forth and they approved are somehow racist or specific to this county because of it being people of color. And, we see that these laws are not specific to just Prince George's County. They happen in other counties as well for various reasons. So I do want to highlight that. We'll go to the next one. Also, so there is a coalition. So this is a grassroots coalition of alliances who oppose HB 980. We have so many different people, AMP Creeks, Clean Air Prince George's. I'm not going to go through all of them, but Friends of Oxon Hill, Maryland Legislative Coalition, the NAACP. This is the NAACP, right? Our Resolutions Prince George's, the Prince George's County Young Democrats. These are all people who have signed on as coalition members. And one of the things that we have to remember when we're engaging with elected officials is oftentimes they say things like, hey, I listen to the people, I listen to the organizations. Our elected officials and the delegates have gotten over 200 letters opposing this bill, and yet this bill is still moving through the House, or still has moved through the House and is now in the Senate. So it's very important to see that these are all people who are against this, who are speaking out about why it's an issue and why we don't want it to continue.
Next.
Oh, there you go. Sorry.
So some of the basic points in the public ethics law to apply in Prince George's County, and these are pretty common sense provisions, common sense protections. They prohibit developers from contributing to county council candidates in a certain span of time. One is within 36 months prior to applying for certain approvals, including zoning map amendments, including conceptual site plans, preliminary and others. One is once the application is filed and accepted by the planning department, then while the planning board and district council are considering the application. And then when I think within 30 days after the council issues a decision on one of these applications. Pretty straightforward stuff. Next. It requires certain disclosures. It requires certain transparency. Good thing. Sunlight. Requires property owners, contract purchasers, and applicants to file affidavits, ethics affidavits, stating whether they have contributed to campaigns of sitting council members. Sitting council members, not the candidates. It requires the applicant's agents, that include their attorneys, their land use experts, their project managers, folks like that, also to file affidavits, but only if they have contributed to sitting council members. And there's an issue there that we'll get to later. It's a loophole in the law. Go ahead. It requires the developers to disclose really who in their group may have a significant interest in either the property or the project. In this case, it's more than a 5%. What we have found in looking at zoning applications is, at least in our case, they didn't declare straight out, or they didn't provide the required information. They just thought it was kind of a pro forma thing where they could scribble a few words on a page and get it done. They didn't fill it out properly, but also the planning department didn't flag them for doing it, nor did the council. We had to police it. Even when we raised it, the issue was ignored. Okay, next.
Can I say something about that real quickly?
Sure.
I just, for like a very quick piece of history on this, the council is only even going through this affidavit process in any form because of a lawsuit that occurred about a decade ago and went on for 8 years. And that was, that had to do with 2 of the sub-region master plans. When the council was considering those, we contacted them and said, look, you're not filing these affidavits, you're not being transparent, and this is against the law and you need to do that. So we're just warning you before you vote. And they said, we don't care. And they voted anyway. And that was an 8-year court battle. So at the end of that 8-year court battle, they started filing the affidavits mostly, but
And I can tell, yeah, sorry.
The law was in place already. So I'm just, for history, you know.
Thank you. I can tell you also, the policing is completely inadequate. In our case, 3 of us went down as volunteers to Upper Marlboro, to the clerk of the council's office, spent hours going through the case file with hundreds of thousands of pages. We confirmed that the required ethics affidavits were in fact not in the file. We sent letters with our own affidavits attesting to the fact that what we had found or not found to the clerk of the council. We did it twice, and we got no reaction. It was only when our attorney wrote to the council that we got some attention. We shouldn't have to do that. We should have to pay an attorney to alert the council of the fact that these ethics affidavits aren't in the file, and they're supposed to be in the file at least 30 days before the council hears a case. It was only when the People's Zoning Council stood up on the morning of the hearing and said, you can't hear the case because I looked at the file and the affidavits aren't in there, you have to postpone. We got word that the case had been postponed when we were in our cars driving to Upper Marlboro for the district council hearing. That's how it worked in our case. Go ahead. Sorry. Oh, additional transparency requires the council members to file affidavits when they have received contributions. Common sense, right? It requires council members to disclose that they've engaged in what are prohibited ex parte communications with the applicants. That you probably know it. That's communications outside of the hearing process because the council convenes as a quasi-judicial body. What we found was the council members wouldn't talk to us, even though the prohibition was specifically against the applicants. And if a council member has received one of these prohibited contributions, they are not supposed to participate in the case at all. They're not supposed to discuss it. They're not supposed to vote on it. We found violations on that point too, but too late to hold them accountable at the hearing. Next. So when Councilmember Turner has gone before the delegation and before the House Environment and Transportation Committee, he said, well, we didn't realize this would be a problem. And I might not be the only one on this panel who ended up scratching his or her head over this one, because the ethics law has this language in it. It specifically names the kind of applications that the ethics law applies to in Prince George's County. The first item is a zoning map amendment, including a countywide zoning map amendment. Now, they said also, well, this is the first time we've done this in a very long time, maybe 50 years. And that's kind of a valid point, but they also were going through this process for 6 years. They've been receiving applications and affidavits since at least early 2020. And yet somehow it was a surprise, maybe in November, that there was this ethical conflict that would make it impossible for them to achieve quorum to hear testimony on the draft countywide zoning map amendment. So it also applies to these kinds of plans. What I would point out here is one of the kinds of plans that the ethics law does not apply to, unfortunately, is what's called a detailed site plan. And far more detailed site plans go before the council than these other kinds of plans. So there's already this big loophole in the ethics law. So House Bill 980, which started as PG 416, next, I'm sorry, we're going, would essentially exempt the countywide zoning map amendment from these protections. And it could apply retroactively to violations that have already occurred. Illegal contributions that are currently prohibited under the ethics law could be made legal by this bill. It could also legalize future contributions that would otherwise would violate the current law. And in doing this, it would say, well, come on in, file your applications and send the council contributions. And that's hugely problematic.
So yeah, if I could ask a question there, Greg, you're saying it opens it up because applications can still continue to come in? Is that the problem?
Well, the applications can still continue to come in anyway. This would essentially, if a developer feels constrained from filing an application now because of contributions, if this law takes away that prohibition against contributions, the developer will have no constraint. They can just come on in and say, I would like the district council to do the following for me as part of the countywide zoning map amendment. And we already have seen some, we'll get into this, but we've already seen some applications that were filed as of early November. Others may have come in since then, and we can expect more to come in going forward until the hearing. I think we skipped them. I think we skipped that. Let's skip back to that last slide.
Oh, sorry about that.
Or did we miss the slide?
1 second, let me just, so.
Yeah. So there's been all this talk, and proponents of 980 have said, oh, you can't do this. The county put all this time and money and energy, and so did the community, into the rewrite. Well, yes, that was done. A lot of time and energy and money was put in the rewrite. We're not saying that's not true. Some of us participated in it. Can we go back to that slide? We keep skipping.
Mm-hmm.
Rejecting House Bill 980 would not kill the rewrite. The rewrite is enacted law. There's no expiration date on it. It doesn't expire if the council doesn't move forward with the countywide zoning map amendment by a certain time. That's just not true. It wouldn't prevent the council or the planning board from hearing public testimony at some point, but that's if and when the council and developers comply with the ethics law. And it would not prevent the council from approving the countywide zoning map amendment and implementing the rewrite once the council and the developers comply with the law. And that's really all we're asking in our opposition to HB 980. The law isn't perfect, but it's important, and it's largely reasonable, and there's no reason to give the developers who have given contributions or other folks basically a get out of jail free card just because they were either not paying attention to or ignoring the law. Next. Next slide, please. So this is what, all right, so I was told I need to explain this. You know, we're being treated like mushrooms. We're being kept in the dark and being fed compost. So Chief, I've actually done a lot of work on transparency in Annapolis. We got the Public Information Act amended back in 2011 to make it really clear to public agencies that to provide the people who request documents in electronic formats, that the agency has to provide them electronic formats rather than giving us big stacks of paper or dirty scanned PDFs. So we're familiar with this, and we've worked with the National Freedom of Information Coalition, Society of Professional Journalists, and other organizations to push that through. So last week was National Sunshine Week. It celebrates the National Freedom of Information Act, the Maryland Public Information Act, and other transparency laws. And so our question is, here we are, we're looking at a transparency law, an ethics law, and the county is asking the state to undermine these really essential protections. And our concern is not only that it undermines the public's right, doing this undermines the credibility of the county decision-making process. And these laws are in place for a reason. They make sense in general, but also Prince George's County has a history of problems with ethics, specifically around zoning and land use. We can remember all of this with the Johnson administration, with a former council member being sent to jail. So I don't think I need to say more. There's been a fundamental lack of transparency around the county's attempt now to undermine transparency. Next. So, and to put a point on that, we did our best to do our due diligence. We wanted to understand what the real issues were and what the impacts might be. So we met with Councilmember Glaros way back when, right after the delegation's hearing on this bill, had a long conversation. And we said, look, we're really concerned about lack of transparency. Why hasn't the council published the affidavits and the applications that it's received already? Publish them, put them on your website. And she said she supported that. Well, here we are. The council hasn't published it. So Chief and I put in a letter to the delegation saying, please don't act on February 16th, saying, please don't act on the bill until the council has published this information on its website and inform the public, civic organizations, and other parties, so we can all look at it. And so the delegation can look at it and make form our understanding of what the issues are. Still hasn't happened. This has come up in hearings where Councilmember Turner has testified in front of the delegation, in front of a House committee. And he claimed that the council could not release the information unless it received a written request under the Public Information Act. It's completely false. The council publishes information on its website all the time. The planning department does the same. They could have done it by now if they wanted to, if they were interested in transparency, but they haven't. Next.
I think Kelly has lost connection. So let me restart the presentation.
Right.
And I'll share screen, but you can go ahead and give it.
And I'm sorry, we know a lot of questions are coming in.
I'm in the chat. I'm trying to answer a lot of them in the chat, so it should be fine. I do want to say an anonymous attendee said, can you comment on how best citizens can make use of the Maryland public access laws and regulations? And what I will say is, and I'll let somebody else jump in as well, you can send emails directly to the people that you're requesting information from. It's MIPA, MPIA, and pretty much just put it out there. This is what I'm requesting. This is what I'm asking for. There are things that come along with that because I think at a certain point you would have to start paying for, I believe, get a lawyer from MPIA. You'd have to, there's things that come along with it because you'd have to start paying for, I think, paper and labor after a certain number of information. And they do take a long time getting back to you in regards to information. And like I said in the chat, and I'll say it here because it needs to be said, I see Councilwoman Glaros in the chat and she's making comments and I appreciate that. But there's a lot of things that I see that she's not addressing or answering or speaking to that we are directly talking about. And one of it would be that, you know, there was a meeting with her with several advocates on this call right now that are presenting. There was a request for that information and it still hasn't been put forth. So we still don't know like who is getting what from where and how much. And then also how that ties to applications that are going in or would be proceeding going in. So I think it's very telling what isn't being talked about or what isn't being responded.
So
Greg, just
at the end of this presentation, you'll see our email addresses. If you send me an email asking about the Public Information Act, I can provide you with really good basic information. Next. Oh, here we are. So one of our big concerns is developers through this CZMA process can submit applications to rezone their properties. They can ask for something other than what they see the county is assigning through the draft. And we've already seen that developers are doing this. We haven't seen all of them. We're quite clear we haven't seen all of them, partly because the county, entirely because the county has chosen not to publish this information on its website. The council does not have to have a Public Information Act request to provide this information. It's public records. They can post it on their website if they want to. They haven't. These applications would not be subject to the normal review process, where often in some cases, the application would be reviewed by the planning department staff, a technical staff would be published, the CZMA staff report would be published, the planning board would hold a hearing, and if the district council decides on its own to hear arguments on the planning board's decision, or if a concerned party appeals to district council, then the district council will hear it. That doesn't happen here. All of these applications, as we understand it, would be lumped together and heard along with the entire countywide zoning map amendment at a hearing, a joint hearing convened by the planning board and the district council. And then the planning staff would take the comments from the hearing and put out a report, put out a revised zoning map, draft zoning map amendment, and then the council at some point would vote on it. And this is one of our concerns. You know, we need this. The process that we have now is highly imperfect, but it's better than this fast-tracked or short-circuited approach that we would see that we're looking at through the countywide zoning map amendment review. And the process that we have now, as imperfect as it is, it's essential to giving the public a chance to see what's proposed, develop an understanding, comment, and build a record. Sometimes all you're doing is building a record on which to appeal, either to the district council or to the courts. Short-circuiting that makes it far more difficult to be able to take those essential steps. Next. So here's what we do know. And we kind of don't know what we don't know. That's one of the big problems. By early November, the council would receive more than 800 ethics affidavits. Some of these, in some cases, you might have multiple affidavits that are connected to a single application. We don't know how many applications have been received because of what we've seen. It isn't clear whether or not there's an application that's already with the planning department, but that hasn't been lumped together in what the council shared with the reporter. What we also know is all we've seen is what was filed as of early November, ostensibly. Developers may have filed more affidavits and applications since then. And as far as we know, they'll still be free to file even more to close to or right up to the joint hearing on the countywide zoning map amendment. And again, if the General Assembly amends the public ethics law to exempt the countywide zoning map amendment, we're concerned that could declare open season. Come on in, file your applications, make contributions without any constraints. Next. So instead of being transparent, back on November 6th, then Council President Turner issued a statement saying that the hearing had been postponed because, quote, certain disclosures prevented the council from attaining a quorum. Nothing about ethics affidavits, nothing about applications, nothing about campaign contributions. And then they've either failed or refused to publish the affidavits and applications. And then we do know that a reporter did file a Public Information Act request with the council in early to mid-February, and the council took nearly the full 30 days that it's allotted to send those files to the reporter. Most of those files had been created by early November. It would have taken the council about 5 minutes to send that information to that reporter. But the bill was in play, and the files were not sent for quite a while, undercutting everybody's ability to understand what the issues are. Next. And by the way, in my experience, this is a pattern with Prince George's County government. The government's not unique, but there aren't very many information requests I have put in where a county agency hasn't either violated or danced along the line of violating the Public Information Act. Again, rejecting, and this is going to be really clear, despite the fact that supporters of House Bill 980, despite their claims that the sky will fall, the earth will stop spinning on its axis, the zoning rewrite will die, and the council will never be able to consider and vote on the zoning map amendment. That's not true. And we're not aiming to kill the rewrite. That's not our goal. It never has been. We would like to see certain problems addressed and fixed, but all this would do is require the county council and developers to comply with the ethics law. That's it. It would introduce some delay, but we didn't create that delay. It's not the concerned organizations and residents that are creating this delay. It's the illegal contributions by developers and its potential ethics violations by council members. But really, they should. That's. I'll leave it there. Sorry. Next. So that's mainly it for our presentation. We can tell you where the bill stands now. It was passed by the House of Delegates the other day. It now has crossed over to the Senate. The Senate, the Prince George's County delegation to the Senate will convene a hearing on Wednesday evening. The bill will be referred to the Senate Education, Health, and Environmental Affairs Committee. That committee will hold a hearing. It will vote on the bill. Its report will go to the full Senate, and the Senate will vote on the bill. And so there are still opportunities for people who are concerned to ask questions and to weigh in with their senators. And frankly, I'm of the belief that if your delegates voted for the bill and you're unhappy with that vote, you should let them know. Because this bill has advanced because the Prince George's County government asked the Prince George's County House delegation to sponsor it. The delegation did. And then the dynamic in Annapolis is delegates in a local delegation are reluctant to disagree with or go against the wishes of the local government. But then delegates from other jurisdictions are reluctant to go to vote down a county-only bill put forth by a local delegation. And so that's what we're hearing. We're hearing delegates say, man, I have serious heartburn about this. I have serious concerns about this bill. If this bill were coming before my delegation, I would probably vote against it. I think it's bad ethics. I think it's bad policy. But out of deference, out of courtesy to the Prince George's County delegation, I will hold my nose and vote for this bill. They've practically said that in committee.
Right, and that's why it's very important that first thing we do is contact the senators from the county. We need a number of those senators to oppose it, to give the rest of the senators in the state some cover to be able to do what's right. So it's very important. I mean, we want to reach all the senators, But it's most important right now to really focus clearly on the Senate delegation from Prince George's County. So, and first I'd like to shout out to my delegate, Julian Ivey, who I believe was the only Democrat in the entire assembly to vote against that. And we know a couple of folks that couldn't be at the hearing because of some personal crises and issues that would have voted against it. But so I would like to give him a shout out. But also I think that, as has been said before, we've had some issues in the county with backroom, the perception, the process of development being influenced by money, in some cases being driven by money. It's been frustrating as citizens for these years to still have problems, so clear problems with the process and the system. This is clearly an embarrassment to the county council. Unfortunately, I think now the House delegation is going to find it's an embarrassment to them, but this is more than embarrassment. This is a violation of the law. If we're going to have a better development process in the county, we need to have processes that afford meaningful input by the citizens, and so that we don't feel that we go through all the public processes. We asked in the middle of the pandemic last summer, we asked the planning board, could you just delay? We didn't even hear about this big development in the floodplain near the metro and for 6 months. We didn't know about it. It's a pandemic. Could you give us a little delay? No. The only one that can ask for a delay is the developer. They don't want a delay, so we're going to go ahead. So we don't get a break. It is not, in my view, adequate for the council and the state legislature to say, this isn't a big enough issue to, this is not big enough. This isn't a violation that big. I think the law has consequences, and I'm tired of the attitude that I keep feeling of entitlement from our county council and the planning process. There's an entitlement to the developers and to those who make the votes. And it's time to draw the line. The state should say, no, we have an ethics law. Sorry, draw the line, deal with it.
I just wanted to add something to what Dan said, and that is, I also want to give a shout out to my council member, Mary Lehman. Mary Lehman voted for HB 490 when it was in delegation, but by the time it got to her committee, after extensive discussions, she voted against it. She changed her vote and she voted against it in her committee after taking a number of amendments to the council and the council saying that they didn't want those amendments. So she did register her opposition vote, and then, as Dan said, she was unable to get to the floor session because of a family issue, and so she was not able to vote there. So we have 2 people who have opposed this bill in our delegation on the record. So, I mean, yeah, Kelly, sorry.
No, go on, Sister.
No, I just want to say people have raised the issue that we should, we could wait this out, right? And then get back to discussing it when the time period prescribed by the ethics law has lapsed. The other question I have is, why do we have these applications as part of the CZMA? If we did not have applications at all as part of the CZMA, which is where I started right at the beginning, if we had a clean process which simply involved the rewrite, which has the new zones defined, and the mapping 1-to-1 by the planning board onto the Prince George's County map, followed by hearing where those of us who have concerns can raise them before the county council, and the county council would vote on it, we would not have applications and we would not have this ethics problem that is currently facing us. So, another way to do it is to simply get rid of applications and then have a clean process going forward.
So I'm going to respond to a point that Councilmember Guaros just posted saying that the HB 980 is a narrow bill. You know, we heard the same thing when Councilmember Turner, who was then Council President Turner, put in a zoning text amendment bill, and that we said, after looking at it, could open hundreds of acres of open space up to intensive townhouse development. And Councilmember Guaros said, no, I talked to Mr. Turner, and he says otherwise. And Councilmember Tavera said, you don't know what you're talking about. But when the planning staff heard our testimony and ran the analysis, they said, yeah, Dan Muth and Greg Smith have a point here. It could open up a lot of open space to townhouse development. So we had done our job. We had done our analysis as best we could. We had gotten data from the county GIS department, and then we gave our testimony. We were told, you don't know what the hell you're talking about. And then it turned out we did know what the hell we were talking about. And this happens all the time. We're assured, don't worry. You don't really understand. It's very complex, but often, and I can tell you, I know of a developers coming in for a fourth or fifth bite at the apple to get intensity on their property, and we've had to fight them for 3 years. And they've gotten as far as they can by the district council ignoring the law and giving them exactly what they asked for, including building townhouses in the floodplain.
And on that same note, of the few ethics affidavits we have been able to go through, I saw in just like a very short list, at least 3 who we have been fighting with for about a decade because they keep trying to upzone at such density, like such increased density. It's just wildly inappropriate. Nobody wants it except for them. And they can't get their projects passed through normal application processes. So they keep trying to go through things like the master plans or this or other, weird, like broad processes. And it's just not the appropriate place for that. I mean, like, I think we all know this, right? This is an administrative process. It should be very simple. Applications have no place here. There's no reason that anybody should be saying, hey, I'd really like to build a shopping center. Hey, I'd really like to build condominiums in an open space zone or something like that. There's no reason that developers should have a part in this process at all, because it should simply be the zoning is rewritten and that is applied to the map with the good of all of Prince George's in mind, not with the good of a specific few developers and their specific parcels, just piecemeal that don't make any sense for the rest of us. And that is, I saw also in the chat that this is a very narrow bill. I keep hearing this is a very narrow bill. This is just allowing this one little thing. It's not a very narrow bill. Number one, it's an ethics bill. It is a bill that would allow a loophole in the ethics law and essentially allow the county council to just break the law. It's unacceptable. We should not have a government that needs to break the law in order to function. You're not functioning at that point. That's unacceptable. Number two, the zoning rewrite affects every single person in the county, whether your property is changing, has a change in zone or not. If the property next to you gets zoned, or down the street, or by your best friend's house or something like that, we all live here. So when these big developments pop up, like a pox, or weird developments or things that are just not appropriate for where they're supposed to be, that affects all of us. We have a right to be protected from those things. And frankly, we have a right to not spend all of our time and money chasing the county council around like a bunch of badly behaved children. None of us want to do this. We're not getting paid to do this. We're volunteers who do this. And it's insane that without us all doing this, the council would just be running willy-nilly with this kind of nonsense. That's not okay.
What it feels like, I think, again, is that there is the public process, and then there's the other process for the developers. And I asked for years, kind of like, why is it that we go to meeting after meeting of a sector plan process development and see very few developers participating? they're not participating in that process, with just a few exceptions. Yet there's still changes are being made in that process. Their word is being heard. So it just feels like we've got systems that are not being followed. And so I think that's what we need, is confidence in our planning and development and zoning process and system. And this does not help build confidence at all. It further erodes that. And that's going to be, it's hard to overcome.
And I want to address Councilmember Glaros's statement that they didn't take developer money. First of all, we need to do a deeper dive to determine who received developer money. Second of all, there can be a difference between taking developer money and inviting developer money and receiving it, but not requesting it, or receiving it, not being aware that you've received it. We understand that there are differences. We understand that there may be innocuous, naive mistakes. We also understand that a lot of the developers who are out there and their agents are not naive players, nor are some council members. So it's pretty well known that certain council members are fully welcoming of developer contributions, and they get them. It's also pretty well known that there are council members, if you looked at the information, don't get a lot of developer contributions, but they get a lot of contributions from other elected officials who have received developer contributions. And that's a loophole in the ethics law. That is permitted. And we're not talking small amounts of money. I know of one council member who has received close to $20,000 from a state delegate since 2010. That's not chump change. And I'll talk about a couple of other loopholes in the law. Applicant developers are not required to identify their agents as part of the application process. So you can and agents are prohibited from giving contributions, but sometimes you don't know who the agents are at all, or until late in the process. So then you get in this game where you have to, the residents have to spend their time identifying the agents and looking at everybody's campaign contributions report, and then figuring out whether the agents gave directly or through LLCs or corporations. And I'm not being hypothetical here. We have found it. Okay. That policing is not being done at the council level. It's being done by us, if it's being done at all. Another loophole created last year, the General Assembly at the last minute exempted the county executive from the ethics law. That opened the floodgates. I know of one developer who, along with two of his family members, on January 11th of this year, gave the executive $18,000. That same developer was pardoned by Donald Trump on January 20th of a felony related to development in another jurisdiction. So and detailed site plans aren't covered. They're among the most common applications that come before the district council for a final decision. That's exempted from the state ethics law. And the zoning rewrite would eliminate conceptual site plans altogether. That's one of the few major plans that comes before the district council that's currently covered by the ethics law. So bit by bit, we're seeing this erosion of the state ethics law and the common sense essential protections it provides to communities.
I want to recognize. I'm sorry,
Kelly,
Gina.
No. I just want to say something real quick. And Kelly, I know you're probably going to say something back there. Councilwoman Glarus, stop gaslighting us. Please stop gaslighting us. I'm okay. Come on now. Stop gaslighting us. We literally just gave a whole presentation on the issues. We cited things. We gave examples, historical examples, legal examples, documents. We had a PowerPoint. We talked about the vote. We followed it. We showed you why there's issues with the vote. We showed you the issues that have been consistent with the issues of this bill since you put it up. Stop gaslighting us by making it seem as if we don't know what we're talking about. We haven't researched the issue. We aren't putting forth good points, and that we have no reason to be concerned. Stop. That is a problem that a lot of elected officials have in regards to listening to their constituents. You're not going to make us seem crazy on this record. And I know it's recorded. You're not going to make us seem crazy when we sat here and just gave a whole bunch of evidence that supports what we're saying. And like somebody else said, we got lawyers who have researched this. We had time to look at this. We had time to look over this, and we don't get paid $120,000 a year and drive cars that are provided by the citizens of Prince George's County. So if you're going to have a real conversation in the chat and say things in response to what we're presenting, then you answer our questions, you answer all the statements, you address what's being said. Don't pick and choose who you want to respond to. Don't just respond to Danny, who is awesome, by the way. You respond to everybody, but don't gaslight us. Go ahead, Kelly. Not today.
You went about where I was going to go, but much more eloquently. I was just going to say, I wanted to recognize how much anger I was seeing in the chat and how upset people are, justifiably, because so many of us have been in one way or another around this block. We know what's going on. People are not stupid. And at the end of the day, although we went through a great deal of information about zoning, we went through a great deal of information about the ins and outs of the public ethics law and the details surrounding it. What we really need to just go back to is this bill that's being proposed, has passed into the Senate, rather, HB 980, is a bill that allows for the law to be broken. It allows for the county council to act unethically because they cannot manage to function otherwise, unless they wait the prescribed amount of time, the amount of time prescribed by the law, and then during that time, work with people like us, work with anybody on this chat, work with community groups, with anybody they want to make a stronger rewrite and map amendment that everyone feels good about. And when the time is right, when they're allowed to vote again, they vote. We also know that there are council members who don't want to wait because they'll be off the council. They'll be term limited by the time those months are up, and they won't get to vote on their baby. And it's a shame. I understand you work really hard on something, you want to see it through, but the fact of the matter is that doing something right is more important than doing something quickly. And we don't have to rush this thing. This is not an emergency bill. This is not an emergency. What's an emergency is making sure that Prince George's County follows the law. And when you contact your senators, which we hope you are going to do as soon as possible, please focus on that as clearly as you can, that we are here in Prince George's County. We are asking you as our representatives, as our elected representatives, to require that the law be followed, that you oppose this bill and simply require that Prince George's County follow the law.
Thank you, Kelly and Jana. I'll just say this. I've known Councilmember Glaros for a long time. I know she's a hardworking, policy-driven legislator. I can disagree with somebody and still respect them. I strongly disagree with Councilmember Glaros on this, and I strongly disagree with idealizing the planning process. When we go before the district council and the local member demonstrates she knows nothing about the law, and then the deputy general counsel for the planning board cites the wrong piece of the law and trying to explain what's going on, and the council member says, "Oh yeah, thank you very much," and everybody knows that they've made an error, and yet every time we turn around, the council just goes along with the local council member, no matter how unwise or illegal a decision is. And then the only way we can get any relief is to spend time, money, and energy suing the council. This is how we end up where we are. And when this question about transparency around this very issue is raised in a timely way, and we still have no transparency, this is why we are where we are, having this conversation and having the community have to work its fanny off to defeat a bill that never should have been filed and that shouldn't have been necessary. This is a huge problem. And I think that, anyway, I'll
Yeah, and I think it's time to wrap up, and I think we appreciate folks for joining us tonight and diving into this. The most important thing we can do now is contact our senators. And I think I would just like to say that it seems like my final comment would be that too often there seem to be carve-outs in the law that some people can find or allow or to get by to get their way. And that's really frustrating when that occurs. We want a process that is clean and clear and followed, and that we want officials who will say no to the developers. We're not going there and considering applications at this part of the process. It's not appropriate. And to extend that to the state, we don't need a carve out in the ethics law for this vote. It's not that important. The integrity of the process is more important.
And this is actually written as emergency legislation to take effect July 1 rather than later in the year as a non-emergency bill. So
Jen?
no.
So, yeah.
Jenna?
Jana, yes. So I'm gonna go ahead and wrap up. I do want to emphasize to everyone on this call, it is not that we don't want rezoning to happen in Prince George's County. That's not like where we're at. We want it to happen. We just want it to happen appropriately, following the law and doing it without the developers having such a hand in it, and that the people who are actually living here have a hand in what is going on. And we don't feel like that's happening through the process that is going on now. That is long and short. Don't let anyone gaslight you and feeling like you don't know what's going on, and that the purpose of this is to stop progression in Prince George's County, because that's not the purpose. We all want Prince George's County to progress and succeed in an appropriate manner that takes the voice of the citizens as its guiding light and not its rear view mirror. And that is really the point. And so subsequently, we really want you to reach out to your senators. We really want you to tell them, hey, look, stop this bill. Reach out to Paul Pinsky, say, look, we are against this. Reach out to all your neighbors. Draft your own email and say, hey, send this to Paul Pinsky, and tag everyone in the Senate. And you can reach out to more than the Prince George's County delegation. You can reach out to every senator that there is and let them know that, hey, the Prince Georgians do not like this. And we have said this on the delegation level and nobody listened to us, and we still don't like this and we want to wait. I think one of my compatriots said it best: it's better to do something right than do something quickly. And if they waited 6 years, they can wait another 1 or 2. It's fine. We are not going to crumble down and fall tomorrow.
Thank you, Jana. I think that is really good. Did you have something to say, Greg?
Just if we could bring up, we have the action page. It's somewhat generic, but does anybody else?
Yeah, I just wanted to say that we have sent a huge number of messages to the delegates, not just to our delegates, but to the entire House of Delegates. So the email alerts that we have sent out, people have responded to in droves. There have been over 200 emails sent to the committee, the Environment and Transportation Committee, another 200 emails that went to the full House of Delegates. So every delegate from every county in Maryland is aware of this issue and that Prince Georgians don't want this. We will send draft alerts out to all of you for the Senate. You can click and send it. You're also, please, more than welcome to write your own letters and send it not just to our senators, but to all the senators in the Senate. I think that is exactly what we must do to address this bill if we don't want it. Any last words from anyone?
If you're on our outreach list, you'll receive our alerts. And thank you, everybody, for attending and staying with us. We know that some of this can be pretty dry. We hope we've done a good job for you, and we really appreciate you taking time on a beautiful spring Sunday evening to hear our presentation and ask us questions. Thank you.
Thank you so much, everyone.
Thank you so much, everyone.
Thank you and good night.